Washington Court of Appeals Division 1 is now in session. The Honorable Stephen J. Dwyer presiding.
Go ahead and be seated, everybody. First up is Haley versus Amazon. Counsel.
Good morning. Daniel Prince for Appellant Jeff Haley. I'd like to reserve 5 minutes, please.
5 minutes? Okay. Good.
May it please the court, this case concerns $192,000 that Amazon deducted from the account receivable of one of its vendors. Amazon's deductions, we argue, were wrong. Each deduction violated the Consumer Protection Act, and we respectfully ask the court to reverse the summary judgment ruling below. I'll take the court's questions.
What evidence did you put before the trial court on the public interest element of your CPA claim?
We proved the public interest element in a few ways, Your Honor. For the fourth deduction, we proved it by showing that Amazon did the exact same thing to another vendor. The GoPed case is on all fours with the facts.
Well, that case ended up, did it not, with the plaintiff losing?
Correct. And we distinguished why.
That's a notable bad fact when you're trying to analyze and analogize to another case.
It is. The reason for that disparate opinion is that GoPed kept selling products to Amazon after the purported agreement that Amazon said it recorded an acceptance for took effect. Haley, in contrast, did not do that. And for that reason, the court could not possibly construe.
Did not do that after the 2018.
For the 2018
but
one.
Continued to sell after the 2012.
It did. Correct. We're not challenging the initial validity of the 2012 one. We are challenging the initial validity of the 2018 one because there was no meeting of the minds. Just as a cable company can't sign customers up and charge them based on contracts that they never consented to. To continue with your question, the evidence for the third deduction is similar, but we think we've shown reasonable
on the
inference.
fourth one, did you do anything other than cite the trial court to that case
We described the facts of it
from the case itself?
extensively. I believe we
From
even
the case itself.
from the case itself.
Are you aware of any other Washington State cases or any Washington State cases that have held that citing to a single out-of-state case establishes the public interest element where the opposing party, and I forgot to even turn on their darn clock here. There we are.
I was going to point out.
Where the opposing party has a business as large as Amazon? I mean, do you have to get past an element of randomness to establish a public interest element?
Well, we need to show under Benke, the likelihood of repetition.
Well, that's what I'm getting at. If you've got one other person or one other instance in the history of maybe the largest corporation of the world and all of its transactions, does that meet the threshold? Does that rise above an element of randomness?
We believe it does. We believe there's certainly a genuine issue of material fact as to whether it does.
Well, would that be a jury question?
The
I mean,
public.
seriously, the jury, how would a jury make that? Isn't that more of a legal question if it has to rise to a certain level? What above zero? Is there an amount above zero that has to be shown? That seems more of a legal question.
It's a good question, Your Honor. Trujillo showed a few cases. For Amazon, we've showed one, as well as reasons why there aren't more, which is Amazon retaliates. against those who speak out about its business practices. And that gets to the generalized course of conduct for the public interest element.
So this is we're talking about a Consumer Protection Act claim. You sold to Amazon. Were you a consumer?
Well,
Or was Amazon the consumer?
the
You're the
consumer
seller.
the title of the Consumer Protection Act protects against unfair and deceptive business practices. It has been held to apply to merchants dealing with one another for the sale of goods. And we
But is that on the part of when those merchants are the purchasers as opposed to the sellers?
yes, the Schrader v. Fagil Motors case applied it in that way.
So how is it that the public is affected, and what evidence did you put in the record to that effect?
Well, the particular public that we are mad about here is the percentage of the public that does business with Amazon.
Well, that's not so, because the vast majority of the public that does business with Amazon are purchasers.
and
And this
users.
is a very narrow subset of the members of the public that do business with Amazon, because most members of the public do not sell to Amazon.
What we think we need to show is that there is an effect on the marketplace due to these unfair and deceptive business practices. In recent, after we filed our briefs, 2 state attorneys general have sued Amazon for its dealings with its vendors because those costs get passed on to the public. And
Well, one of your complaints here is that wasn't able to happen. You would have passed it on, but you didn't know they were going to take your money, so you didn't. So the public wasn't injured in that way. Under the facts of this case, you were.
And we believe under the Trujillo factors and the Hangman Ridge factors that this is still a case that impacts the public interest.
Okay, thank you.
Good morning, Your Honors. Ross Seiler on behalf of Amazon, and may it please the court.
Why did the trial court enter findings of fact on a summary judgment motion?
It's a good question. I think the trial court did to bolster its rulings in terms of the evidence that was presented to it. and that
Why would
considered.
why would I pay any attention to such a thing? Obviously, it's improper. The cases politely describe findings of fact as surplusage. What the cases really mean is nonsense.
I think the fact
Because summary judgment has its own standard, right? You look at all the evidence, you construe it in the favor of the non-moving party.
correct, Your Honor, but in terms of the various deductions, the contract provisions at issue, I think the court wanted to present those in a straightforward way and what it was analyzing in that situation.
Should we treat them as anything other than nonsense?
I think you should treat them as evidence that was presented to
They're
the
not
court that it
evidence. They're
considered.
clearly not evidence. Trial judges don't make findings that become evidence.
Trial judge, though, is required to lay out what it considered in its ruling. And that's
Not by
what-
making a factual finding on summary judgment.
And I think the court can consider the entire record that was presented in this case.
The court meaning this court.
This court, yes.
So we do treat it as nonsense. We just ignore it.
I don't think you treat it as nonsense. I don't think you have to give it deference, but I think it provides
We don't pay any
guidance.
attention to it whatsoever, do we? It's surplusage. At best, it's surplusage.
I think it provides guidance on what the trial court considered in its ruling and the evidence that was
It
presented.
provides guidance when the trial court behaves improperly and resolves factual questions on summary judgment. We should adhere to that guidance.
I think if this court is inclined to not treat the trial court's findings with any regard, then the record review.
So then where does it put us when on the second summary judgment motion in ruling, it referenced its previous findings of fact? So it made a ruling in reliance on something that it never should have done.
I think that the trial court was just trying to avoid repetition from its December 2020 ruling on summary judgment. I agree with you that there is some incorporation of the previous ruling in that, but then at the same time, the Superior Court went back through and made its own findings as to the deductions at issue and the propriety of those deductions.
What do you think it means to disregard a piece of evidence because it's self-serving? Does that make any sense?
Yes, and I think that there is case law that stands for that proposition.
What evidence is properly admitted that is not, from the standpoint of the proponent, self-serving?
In this case, it's evidence.
Not in this case, in any case.
Evidence that has no actual evidentiary support beyond a party's
Well, then it
statements.
shouldn't be admitted, should it?
Correct.
If it doesn't, the test for materiality is whether it tends to make a fact and issue more or less likely to have occurred, right?
Correct. And in this case, we have Haley.
So if a proponent wants to prove something, isn't all of their evidence self-serving?
I don't think it would all be self-serving. I think that when you have
Why would
statements.
you introduce anything that was for the purpose of serving the other party?
I think the entirety of the statements regarding termination that Haley put forward are self-serving. There's no evidence in
What possible difference does that make?
because there's case law holding that.
And there's case law from Division 2, which is very well reasoned, that says those cases are just silly. That because everything that a proponent puts forward is to serve their purposes.
We believe that Haley needs to come forward with something beyond a self-serving declaration and unsupported assertions if he's going to claim that there was any terminate.
So if his unsupported assertions was serving you, they would be okay. But because they serve him, they're not?
There would be no situation where he would be providing self-serving statements in support of Amazon in this case. They are self-serving for
So
their
all
own
of his statements would be
interests.
self-serving, right? It only makes sense.
Not every statement in a declaration would be self-serving. You have his statements about the history of entering into agreements with Amazon, for example. His
Well, that's
statements-
self-serving. He's trying to show what happened and what was the basis for his behavior.
But there's evidence that supports those statements. There's dates on which contracts were entered into.
To counteract it, you presented a self-serving declaration of an employee, right? Who served his own interests by testifying favorably towards his employer, saying that he did his work properly and that based on his training, he wasn't able to come up with any indication that Haley had ever sent this message. That's all self-serving from the standpoint of the declarant.
I don't believe that's self-serving.
Of course
First of all,
it is.
Amazon has an affirmative discovery obligation to search for communications that Haley requested in discovery. We conducted that search. Mr. Viro, who submitted the declaration, searched, retained records.
And he submitted that to benefit Amazon, right?
I mean, in support of Amazon's summary judgment motion.
And
Summary judgment-
Amazon was his employer, right?
Correct, but on
Sounds
some,
very self-serving to me.
I think it's a different situation as opposed to Haley's
Well, I
declaration.
know you do, but I'm trying to figure out how it can be. How is it different than Amazon, which is not a natural person, acts through a natural person to testify to its self-serving interests, but Haley, who is a natural person, is not allowed to testify to his self-serving interests. They're precisely the same thing.
On summary judgment, Amazon was entitled to test the evidence, correct, that Haley was able to put
Not to the
forward.
extent that it causes it to be weighed.
The
If the trier of fact has to weigh the evidence, or, I mean, if the judge on summary judgment has to weigh the evidence, then he's stepping into the role of a trier of fact. And that would, again, be improper, which is a concern in this case, because this judge repeatedly, or a judge, repeatedly did so by making findings of fact.
I would argue that the 2012 agreement requires termination to have been made in writing, and there is no
And
evidence.
he says he
of that.
did.
He says he did. There's no suggestion in any prior briefing. In the six complaints that he filed.
Is that based on his personal knowledge? He contends that it is, right?
He contends that it is, but there is no evidence that supports that in any way.
Why is there a need for any evidence to support that? Why is his testimony not competent? It's based on his personal knowledge.
Because we have case law holding that mere unsupported assertions and self-serving declarations are insufficient to establish a genuine issue of material fact.
Why is
to
that
defeat summary judgment.
case law good law? Why is that not inconsistent with the summary judgment standard? Division 2 says it is in a series of cases.
I believe that because part of the process of summary judgment is to, first of all, prevent unnecessary trials, and second of all, to give
Well,
the non-moving party a chance to test the
if
evidence.
there's facts that have to be believed or disbelieved, then a trial's necessary, not unnecessary.
But there's no evidence that supports Haley's
His
statements in this
testimony
case.
supports it.
Is what you're suggesting that, you mentioned in your brief, there's no corroboration. Are you
Correct.
suggesting that there needs to be other evidence?
I'm suggesting that when Haley comes forward on summary judgment for the very first time in this case that has a years-long saga to it, and states that there were termination, that he sent termination via communications with an Amazon
So you're
employee
saying his
who's unnamed.
testimony is not credible?
I believe his testimony is not credible, and that it's not supported by
who
any
determines-
actual
Who
evidence.
determines whether his testimony is credible?
It's not that it's credible, it's that we have law that says that this is insufficient on its own from Haley to support summary judgment in this instance.
How is that consistent with viewing the evidence in the light most favorable to the non-moving party and not weighing the evidence?
Because he has to come forward with some evidence to establish a
He
genuine issue of
did. He
material
has
fact.
his own testimony based on personal knowledge.
I would say that's not evidence, that is a
It
self-serving
is
statement.
evidence. It is evidence. If he sought to testify to this at trial, certainly he would be allowed to testify to it at trial, because it's evidence.
There was no suggestion in
What
the
corroboration was there for the testimony of your employee?
that we did, that we searched the records.
No, that's
there's
not
nothing that was
corroboration.
produced.
That's his assertion.
Right, but we have an obligation, right, under the discovery rules to conduct a reasonable and diligent search.
That
produce
doesn't have anything
documents.
to do with whether or not your employee should be believed. He just has this uncorroborated assertion that he did these things. It's no different from what Haley did.
The termination issue in this case, we have Haley producing no evidence on his own, Amazon identifying
So,
no
counsel, in a motor
records.
vehicle tort, if you have one person saying by declaration that the light was red, another person saying by declaration that the light was green, we have two self-serving declarations. Doesn't that create an issue of fact?
I don't think it creates an issue of fact. I think in this case,
The red light, green light doesn't
well,
create
I think
any
that
effect?
situation does create an issue of fact. In this case, first of all, Haley specifies that he had communications with Amazon. He does not assert that he terminated the agreement in writing. There is no written record of his termination, and that's what's required for the 2012 agreement to not renew for subsequent years after 2012. And that is the basis for why Amazon's entitled to take the audit
That was not
deductions.
the basis of the trial court's ruling. The trial court ruled because it was self-serving and it shouldn't be taken at face value, which is what you urged the trial court to do.
The trial court found that there was no corroborating evidence for what Haley's statements were, and that he needed to come forward with more than his self-serving declaration and unsupported assertions. And, Your Honor, we asked the court to affirm Amazon's, the deductions Amazon took were validly taken, and that Haley's CPA claim cannot satisfy multiple bases, including the private interest, or public interest requirement that you noted.
Thank you. So Judge Max down in Division 2 has written several cases that say this whole self-serving can't take at face value thing has gotten out of hand. Obviously, any evidence that's been submitted by a proponent is self-serving. What's your view on that?
We agree, and the court asked recipient questions about it. The evidence-
Had Haley ever been asked directly and answered under oath to answer a question and did so in a way that was directly contrary to the testimony that he gave on the summary judgment motion?
In this case, no.
Well, this is the case I'm worried
Okay.
about.
You asked ever, and
I mean, in the course of the case.
yes,
Because
not to my
there
knowledge.
there is authority that says if you're deposed and you say the light is red, and then you submit a declaration that says the light was green, that the subsequent declaration, because it's clearly designed only to create a question of fact, can be disregarded.
Haley has.
So I mean, that's where this whole kerfuffle starts from a very simple proposition that then gets expanded to impede upon people's constitutional rights to have a jury trial. So is that the situation that was here, that he had at once said the equivalent of the light was red?
No.
Okay.
No.
You want to take another shot at your CPA claim?
I do.
Okay.
We believe that the House panel evidence, which is supported by affidavits, and which we asked the court to take judicial notice of, provides ample evidence that Amazon
Can you
retaliates.
provide any authority that would give us the ability to take notice of that?
Yes, the House Subcommittee's report,
Was that actually before the trial court?
yes.
You just provided them with a link.
And the excerpt, I believe.
What was the extent of the excerpt that you claim was presented to the trial court?
I would have to go back to the record, Your Honor. I don't remember offhand.
Okay, go ahead. Because you understand that providing the trial court with a link to something is not putting it before the trial court, right?
Correct.
I
We,
mean, it's no different than in 1957 submitting a writing that says if you'd fly back to the Library of Congress, you could read all about this, right? Which would not be putting it before the trial court,
correct.
right?
We also described in our brief the various ways that Amazon monkeys with vendors' fees and retaliates against those who speak out. And for support, we cite to certain pages of the
But that's a
House
separate
report.
claim that isn't your claim, because you're not saying they retaliated against you. You're saying they took money that wasn't theirs.
So for the first two, we're saying we took money based on a contract that had expired. For the third and fourth, we are saying that those were retaliatory deductions. And we believe that the evidence we've presented speaks powerfully to the fact that this is part of a generalized course of conduct and that it's capable of repetition. Amazon does this all the time with sellers. There is a business that says, if you've been selling to Amazon, we guarantee that Amazon's been overcharging
And
you.
the evidence of retaliation that you submitted on 3 and 4 was what?
Those third and fourth deductions came during Haley's first lawsuit, and so there's
Well,
a reasonable
But
inference.
you got a private dispute between Haley and Amazon.
Agreed.
So what's the evidence that makes this a public matter rather than a private dispute on that question?
Well, we think that the Trujillo factors, Amazon's power in the marketplace. I mean, I've never canceled my Prime subscription. There's certainly evidence that Amazon does this to all different kinds of sellers and that it impacts the marketplace when it does so.
So anytime someone has a beef with Amazon, it becomes a matter of public interest because of their market power?
I'm not saying that, Your Honor, but in this case, we believe Amazon's done wrong and should be held accountable.
Okay, thank you. We're in recess.